So this is a probation violation hearing. Mr. Elhart, you've been retained now to represent Mr. Foz. Are you prepared to go forward with the hearing this morning?
Yes, sure.
Okay, so Ms. Traska, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth? So help you God.
I do.
All right, and if you could please start by telling us your name and how you're employed.
Amanda Traska, probation officer for Leelanau County with District Court.
Hang on just a moment, Mr. Elhart.
If I may, Your Honor, this Praz is here to admit that he is unable to do the community service work.
Okay, so he wants to enter a plea.
Yes, Your Honor.
What about the added violations for, let's see, failed to continue counseling with the cancer center, disrespectful of court employees and care providers, and acting in a threat, intimidating, harassing manner? Okay, so then, Mr. Foz, is that correct? You're changing your plea in this case to guilty of the violations. That's what you want to do, is plead guilty.
That's his direction, yes, sir.
Okay, so it's still your decision, but I understand you've consulted with Mr. Elhart, and that's what you've decided to do.
Yes, sir.
Okay. So before I take your plea, I want to make sure you understand that you do have a right to a hearing at which Mr. Elhart would represent you, and you're choosing to waive that right, correct?
Yes.
Do you also understand that the worst that could happen is for this conviction of leaving an accident causing injury is you could be sentenced to up to a year in jail?
I don't understand.
Violating probation, the worst thing that happened is the maximum.
Okay, so you understand that, correct? Okay. Has Mr. Elhart answered all of your questions to your satisfaction?
Yes.
And no one's used any force, threats, coercion, or made any promises to you to get you to waive your right to a hearing this morning, have they?
I'm going to say no, sir.
All right. Then the report indicates you were placed on probation back in October of 2023 for leaving the scene of an accident causing an injury. And as a condition of that probation, you were to complete 30 days of community service work within the first 180 days. Is that true?
Yes.
And the fact is you did not complete the 30 days in the 180 days, correct?
Before we dive into this hearing, I need you to understand just how badly this man fumbled what most defendants would consider a second chance at freedom. This isn't a case of someone being railroaded by the system. This is a case of a court bending over backwards, and the defendant responding by lighting that goodwill on fire. Originally, this man ran cyclists over with his truck, then showed up to court acting was the victim. Despite that, the required programs verbally abuses court staff, and starts sending messages that cross the line from rude into threatening. What you're about to watch is the probation system doing exactly what it's designed to do: document behavior, offer chances to comply, and then step aside while the judge decides whether enough is enough. Pay close attention to how this defendant talks. Pay attention to how he minimizes, deflects, and reframes everything. Because by the end of this hearing, the excuses run out, and
There's also an allegation that you failed to continue your counseling with the cancer center as ordered. Is that true?
True with extenuating circumstances. It's not true that I refuse or I'm not doing it. As I've mentioned before, a letter was sent from the parole office without my permission or knowledge to my medical providers asking for information on my medical records. When I found out about that, I called my medical provider. They said they deleted the email. Like, this went on for about 3 months, me trying to get the email from my provider. She went to legally refused. And because of that letter that was written by the probation department and my asking about it, they discontinued service. They refused service because they didn't want to get involved in a legal case. I also went to my,
Okay, so I'm going to give you and Mr. Alhart a full opportunity to explain the circumstances of these violations. But for right now, I'm just trying to establish if you're pleading guilty to this. For whatever reason, you did not complete the counseling that was ordered through Cowell Cancer Center, correct?
correct, but not due to my circumstance, due to their circumstance.
The answer is yes.
Yes, sir.
Okay. So, is it also true you were disrespectful to court employees and or service or care providers?
I was honest with them.
Okay, but would you agree that you were disrespectful to them?
To me, sir, that's a very subjective term.
Well, we can have a hearing on that issue. We can
Well-
have Ms. Traska go through all of the emails and other correspondence.
I've got them too. I've got them here as well. And if you mean saying, fuck you and the horse you rode in on for writing that letter and other things like that, yes, I did.
Okay,
If you call that disrespectful, yes, that was disrespectful.
all right. So, and then it also, the allegations are also that you acted in a threatening, intimidating, and harassing manner towards other persons. Is that true?
Right here, the tone is already serious. This isn't a trial about guilt or innocence anymore. That ship sailed when he was convicted. This is a probation violation hearing, which means the only question now is whether he followed the rules the judge gave him instead of jail. Judge is. He confirms representation, readiness, and then moves directly into violations. There's no drama from the bench, because there doesn't need to be. The violations are documented. The probation officer is sworn in. The record is being built carefully, because whatever happens next has to survive review. At this stage, defendants who understand the system usually tread lightly. This defendant does.
And you can take into account whether or not you think the board is appropriate to consider for any sentence.
All right. So, Mr. Alhart, are you okay with that?
I am your.
All right. So then, Mr. Foss, to the first three allegations, how do you plead?
Yes.
Okay.
I'll accept your plea, find it is voluntary, accurate, and understanding. And Mr. Alhart, what else would you like me to know?
Thank you, Your Honor. I'm in the sentencing phase now, Your Honor.
Yes.
Thank you. Your Honor, Mr. Foz was, you had received it, I think, a copy of a letter dated nearly a year ago, where he was given 2 years to live. He may not make it to his next birthday. He's under daily chemotherapy. Cancer has spread to his bones, the rest of his body, and the liver is at correct lymph nodes. I'm sure that he's undergone great deal of modifications to his temperament, the way he behaves, and everything else due to the cancer. I'm very certain, looking at his history and talking to him about his history, what he's done for our country, that he was an exemplary citizen. Cancer has changed who he is and what he is doing. His behavior many times inappropriate. Certainly, I understand his dismay that his medical rights were violated. By the same token, I understand what's going on. He can't do any work of any kind. He can barely make it here today.
Mr. Hart, are you aware that he was given the opportunity to consult with the probation agent to try to come up with non-physical activities that would count as community service work, such as writing letters to veterans?
I wasn't aware of that.
I wasn't aware of that either, John. That's never been proposed to me.
Right here in open court. Okay, go ahead, Mr. Hart.
What was right here on court, Your Honor?
When we were here on the first probation violation. Okay, thank you. Mr. Foss, is there anything you'd like to add?
Yeah, there's a lot that I'd like to add, Your Honor, but it doesn't really pertain to what we're doing here today. I've been really disappointed by the professionalism exhibited by the probation department, my violation of my rights. The scales of justice don't seem to be equal. Inflammatory language, refuses, inflammatory language like that, it's not accurate. It's not true. I never acted in a threatening, intimidating manner. What I do demand is service from my public.
This moment matters more than most people realize. By pleading guilty to probation violations, the defendant isn't just admitting mistakes, he's giving the judge full authority to revoke probation entirely. Once that plea is entered, the court is no longer constrained by leniency. Watch how carefully the judge explains the consequences. This isn't rushed. This isn't hidden. The judge makes absolutely sure the defendant understands that probation was the alternative to jail, and violating it opens the door to the maximum sentence. When the defendant says he doesn't understand, that's a massive red flag. The judge pauses, clarifies, and even offers more time with counsel. That's not weakness, that's due process. And it eliminates any future claim that
I'm not familiar with how the legal system works, but when I am refused service, it makes me a little irritated. I expect professionalism from my public employees, and I admit I've not been professional. I've been irate, and I get that way very easily. Part of it's, as we mentioned before, testosterone has a huge impact on that. It changes your personality. I had a doctor's appointment last week, and I mentioned that to my doctor, and he said it's an effect of testosterone. And the reason I'm unable to perform these tasks is because of my testosterone levels, my chemotherapy, my sicknesses. The reason I missed my last appointment for probation, and I mentioned this to Ms. Trask, I wrote her a letter. I'm very sorry I missed the appointment. I was ill. I don't get my mail every week. I apologized, and I asked her if there was something I could do to mitigate the situation. I never received a reply. So it's not that I'm fighting and refusing to do what you're asking me to do. I will happily do, if I could, sir, I would happily do what you asked me to do, but I'm not physically able to do it. I've mentioned that I would be happy to pay a fine to help out the community, but physical activity service, yeah, I'm not able to do it.
All right. Mr. Chamberlain, anything for the people?
Your Honor, I agree with Mr. Foss that the scales of justice are not equal in this case because he was charged with a felony and could have been charged with 2 others for felonious assault. Your Honor, he got mad at someone who flipped him off. He turned around, drove his vehicle right at them, slammed on the brakes, and one of the people got hit. That person was in the hospital. They had their leg split open for, I believe it was 4 days with a pressure bandage. So from about the top of the knee to about the top of the thigh. And that was due to his actions, due to, as he said, his anger. Mr. Elhart said, cancer has changed him. Well, then that means he's a public safety risk. Your Honor, because I ran the guidelines in this case, and had he been convicted of just what was on here, he's looking at 0 to 14 months. Had we increased it to the 2 additional felonious assaults, it would be 7 to 23 months. That's OV1 for using a vehicle as a weapon, OV2 for the potential lethality of the weapon used, OV3 25 points for life-threatening and permanent or permanent incapacitating impairment. OV4 10 points, serious psychological requiring therapy and other medical intervention. OV9, number of victims. There were 2 to 9 placed in danger. OV17, 10 points for driving recklessly, disregarding life. Your Honor, Mr. Foz thinks he's the victim here. You look at his information or the email, excuse me, and this is what he says for the victim. To be bluntly honest with you, my opinion is the legal system is fucked. My honesty lands me in hot water. Menendez, dishonesty lands him thousands in cash. That's fucked, really fucked.
The classic minimization tactic. The defendant acts surprised that consequences still exist, as if probation somehow closed the book forever. But probation is a test. And tests come with pass-fail outcomes. Notice how the judge calmly walks him through reality. This is not relitigating the original conviction. This is about whether he honored the conditions he agreed to. And when the defendant finally acknowledges that the worst thing could happen, that moment seals the court's discretion. At this point, the judge has done everything necessary to protect the record. Any jail sentence that follows isn't punishment for misunderstanding, it's accountability for choice.